Happy Friday, everyone. Exciting stuff. Blake actually got told no, but that is next episode. So just to update all of that, I'm doing this one now solo about the filing that came out yesterday. And then Omar is joining me shortly after this one. So I'm kind of going to rush through this one just so there's enough time in between the two. And it is also, it's, I was looking through, and I always want to do something special with my thumbnails. And I'm not the first one with the news ever, but I try to be the most detailed, try to bring you additional information, try to explain the latest filings, what they all mean, and of course try to make you giggle a little bit, because this case makes us really angry from time to time. So I try to do a nice and funny thumbnail that you'll all enjoy. And I was like, what could this be? And that the only thing I could just the thought I couldn't get out of my head is that we did not miss this man. We did not miss this man's filings. We did not miss this man's shenanigans. And this one is exactly that. It is shenanigans. So just want to say hey to everybody who's joining. And as usual, with the way my brain likes to wander, I will try to stick to my notes and then spend a little time with comments with you guys at the end. So if you have a question or something really important that you want me to see, please save it for the end, when I will take the time to look at what you guys have to say. And then just kind of right now, just chat amongst yourselves. You guys are usually hilarious, and I love the way you have conversations with each other, but it's very distracting because I want to join the fun. So why do I say that these are shenanigans? Because he comes right out with this really forceful language. The way he says these things with such certainty and with such confidence, just telling the judge that he must do this, that this case absolutely proves what the judge must do. And it's just so dramatic, but it's also just so wrong. Throughout this case, there's been an issue that time after time, Wayfarer has called out. I always called it out too. If you've been watching my stuff for a long time, you know that way back when this all first started, that I like to look into what cases are cited, because what they're supposed to do in their documents is they make a statement and they back it up with citing case law or citing a federal statute or something like that that supports what it is that they're saying. And as I've been saying, as I go through the motion for summary judgment, that's what we've been doing in our deep dives with that. And what I've been saying is that when Wayfarer cites a case, it absolutely supports what it is that they're saying. And as I mentioned so many times in going through that when you have a good case and when you are on the right side of the law, it's not hard to come up with cases to support your argument because you've got it right. On the other hand, when you don't have a good case, or when your argument is not on the right side of law, it is very hard to support it. And so you come up with this situation exactly, that the cases that you cite do not support your claim. Whatever it is that you're trying to say, it doesn't support it. It doesn't match it. So that is exactly what's happened. And I love that Wayfarer has continuously throughout the history of this case pointed it out when they've cited a case that doesn't match or doesn't say what they're claiming that it says. It is a beautiful thing. Now, if you were here the other night when I talked about how there are set times for when documents are supposed to be filed, and once something is filed, the other side has a right to respond to that. And I mentioned a time that Ezra had filed something and there was no There was no um, allotment for her to put that kind of a filing out. And Judge Lyman called her on that and then allowed Wayfarer to respond. Now, this isn't that type of situation, even though there was no room for this. This wasn't something that was due because it was new case law that they felt pertained to this case. They can write this sort of letter. There are some requirements with it. It has to be short and concise. This one is short and concise. And it has to be something new that was not available previously. This is a new case, and it cannot be just an excuse to slip in another brief. And so, arguably, they could say that they followed all of those requirements. That could be something that is disputed in Wayfarer's response, but not necessarily, because it does appear that they did follow all of the requirements for that. I just realized my microphone was wonky. It was turned sideways. I hope you guys were hearing me okay. But, and there goes my printer. But, what is the claim exactly that he's making here? And I really look forward to the response from Wayfarer, because this one is ridiculous. So what he says is that Blake is respectfully submitting this letter to provide notice of the Second Circuit's recent decision, Miller versus Lamanna. In Miller, the Second Circuit held that the district court had committed procedural error. Now he's careful about what he quotes from this case. There's a very good reason that he's careful about what he quotes from this case, because the case doesn't say what he's trying to claim that it says. Now, I don't know if he's hoping that the judge is worn out, because the judge has some kind of big stuff. He just made a decision about a case involving Trump. He's got a lot of things going on at this time. So maybe he's hoping that the judge just takes his word for what this case says. But to me, the absolute desperation and absolute gall to put a case like this before a judge, knowing that how you are applying it is a misstatement. I mean, and that's a nice way to put it. But just choosing the words that he's choosing them for a good reason, because it's almost like, and I'm not saying that he's threatening the judge, but it's almost a threat to, like, okay, there is this new decision, and I've taught you all about binding authority and how the Second Circuit Court of Appeals, when they make a decision that relates to a case that is in the lower court, that the lower court must recognize that as case law, as binding authority. And so they have to make their decisions in harmony with that. Otherwise, it can be appealed, and it can be appealed on things like this right here: committed procedural error. These are signal words telling Judge Lyman, you've got to find just like this case. Otherwise, your ruling is going to be overturned, and no judge wants that to happen, or you're going to be told that you committed procedural error. So it's just a lot of hot air that he's blowing, and he's trying to twist it to sound like something that it isn't. So in the Miller case, the Court of Appeals did find that judge committed procedural error and abused its discretion, although that's not in quotes, so he kind of just pulled that one on his own. We're going to find out why it is different. But I'm sorry, I'm just checking my notes to make sure I did not forget anything. Okay, so we can move along to his next point. His next point is that had such a motion been made before discovery, if the evidence collected in discovery raised triable issues of fact, it would have been appropriate for the plaintiff to amend his complaint to conform to the evidence thus collected. So he's trying to make this a discovery issue because if you take parts of the statements of this decision by the Court of Appeals, they do talk about the point that they are that discovery has already been done for 2 years, and he's trying to distort it as if it just means that because discovery is completed, that this should be happening. And that is not what that case is about at all. Sorry, checking my notes real quick. Yeah, but yeah, you'll see what I mean in a moment, what he's trying to do. So here is the actual case, and it gives a really quick explanation of what happened in the case right here in the opening pages. So this was a discrimination lawsuit, and it was against the Department of Corrections and Community Supervision. Now, it does say after 2 years of discovery, defendants' appellees move for summary judgment, but that has nothing to do with what the judge did wrong. And it's not a reason for the judge to use in this case. It has nothing to do with that, because the fact is the motion for judgment on the pleadings was timely filed, and that is a statement that Judge Lyman made a couple of months ago when he decided to move the judgment based on pleadings and the motion for summary judgment together and gave Blake these ridiculous extensions of time. So that has no bearing on this decision or what the judge did wrong. So what did the judge do wrong? The district court, or Judge Roman, disregarded the parties' factual arguments based on the summary judgment record and dismissed Miller's claims under Rule 12b-6 after having considered only the allegations in the complaint. Miller now appeals that dismissal because the district court erred. This is what the court did wrong: converting defendant's motion for summary judgment into a motion to dismiss. That is what happened here. That is a far cry from just because we're past discovery. And dismissing Miller's claims only on the basis of the insufficiency of the allegations in his complaint. Okay, we're going to get into the details about that. Now, the order does repeat that introduction part over and over again. It's a longer order. I think it's like 30 pages, something like that. I can't remember exactly now. But so we see that repeated again here, that after 2 years of discovery. Now, the defendants moved for summary judgment. They did not file a motion for judgment on the pleadings. And we're going to talk about the differences. All three of those motions are dispositive motions: the motion to dismiss, the motion for judgment on the pleadings, and the motion for summary judgment. They're all dispositive, but they all have their own distinct rules. So he took a motion for summary judgment and just said, I don't feel like doing all this. I'm just going to rule on this like it's a motion to dismiss. That is huge. A judge simply does not have the authority to do something like that. And this is what the Court of Appeals is saying. You erred. You abused your power. You abused judges do have a lot of power. A lot of things are up to their discretion, but it's not unlimited. They still have to work within the rules. And so taking a motion that is based on rule number 56 and saying, I'm not going to apply rule 56, I'm just going to apply a 12b-6. That is not within his discretion to do. So That is what they're saying that he did wrong. Now, let me see, hold on. What's happening in this case? Has this case only had a motion for summary judgment and the judge said, I'm not going to consider this as a motion for summary judgment? No, in this case, we have both types filed. And he has spoken on both of them, and he has said he's going to consider both of them, but he said he's going to consider them together. So this is definitely not the same situation whatsoever. Okay, now we're going to talk about the three different motions, like I said we would. So I'm going to read from this this decision a little bit more. It says, following extensive discovery, defendants' appellees move for summary judgment, arguing both that Miller's complaint failed to state a claim for discrimination and that the summary judgment record did not create a genuine dispute as to any material fact. The district court dismissed the complaint for failure to state a claim under Rule 12b-6. In doing so, the court considered only the allegations in Miller's complaint and disregarded the arguments that the parties had raised based on evidence in the summary judgment record. They say that the district court exceeded its discretion. Okay, so sorry, I'm reading my notes. I just don't want to miss anything. Okay, all right. So these are the three different dispositive motions. A 12b-6, a motion to dismiss. The reason it's called people call it a 12b-6 motion is because it's called a motion to dismiss, but it's based on that federal rule. So as I've shown you all through this case, every step of the way has a federal rule that tells the attorneys how to file, how to act, what to say in their filings, and it tells the judge what to look for in those motions when he rules on them. So a motion to dismiss is based on this 12b-6 rule, and something we learn in the rules, Rule 12, is that it's filed within 21 days of the filing of a complaint and before an answer is made to the complaint. So someone files a complaint in a lawsuit. There is almost always standard across the board, 21 days for the other side to respond to that complaint. And they can respond one of two ways. They can respond with an answer, which we've been looking at a lot in this case, or they can respond with a motion to dismiss, which we've seen also in this case. But that's the timing of it, within 21 days of the complaint. Well, a motion to dismiss is long past that. So you can't file a motion to dismiss at this stage. But this guy did not file a motion for judgment on the pleadings. He filed for a motion for summary judgment. Now, a motion for judgment on the pleadings is based also on Rule 12, but on Rule 12c. So whereas the motion to dismiss, it attacks only the complaint, and it must take the stance as if even if everything in the complaint is true, he has to take it all as true, it still doesn't meet the standard for the actual claim. It doesn't legally say enough. It doesn't support the claim well enough. Even if you take everything in it true, it's failure to state a claim. So it's just not a strong enough legal argument. So a motion for judgment on the pleadings goes by that same standard, but it doesn't just attack a complaint, because at this time you have an answer and then you have a reply to that answer. Those are all together the pleadings. Now it takes the same standard, like I said, but it covers all of those documents together, all of those filings together. Then a Rule 56 motion for summary judgment. Rule 56 tells us that it's filed after discovery, anytime until 30 days after the close of all discovery. But it doesn't just talk about the four corners of the filings. It attacks the evidence. It comes with other documents. Hey, Ricardo. Thank you. Ricardo, as always, says, hi, Miss Cassidy and lovelies. So these are the distinctions between these three motions. If they wanted a judgment on the pleadings alone, they should have filed this MJOP at the time, but they filed a motion for summary judgment. With that, they filed their own. Let's talk about what all they filed. So with their motion for summary judgment, they had defendants submitted, so these are the ones who filed it, 12 declarations, over 50 supporting exhibits, and a local Rule 56.1 statement. We've seen what those all are now, totaling together more than 700 pages. If they just wanted a judgment on the pleadings, they filed the wrong thing. Then, in response, Miller filed his own affidavit supported by 32 exhibits, an affidavit by his attorney supported by 44 exhibits, and a counter local 56.1 statement, together totaling over 1,000 pages. So almost 2,000 pages of stuff, including discovery. They say, although they had styled their motion as one for summary judgment, the court need not proceed to such an analysis because Miller's claims, as pled in the amended complaint, failed to state a claim on which he may obtain relief. They argued that the district court should therefore review their motion under the Rule 12b6 standard. Well, that's an MJOP. But they didn't file an MJOP. So this is not the same thing as the case that we're talking about, as Blake's case. They continue, Miller summarily asserted that because defendants filed a motion for summary judgment, not a motion to dismiss, the court should apply the standards relevant under Rule 56, not those applicable under Rule 12b6. He then argued, with some citations to evidence in the summary judgment record, that there were genuine factual disputes precluding summary judgment in defendant's favor. Miller argued that the evidence in the record was sufficient, and they agreed, and they ruled so. But this case, these cases all are individually decided. So what is true in this Miller case is not what is true in this case. So yes, this was the decision that the Second Circuit Court of Appeals came to for that particular case that did not have an MJOP, only had an MSJ filed. It's not the same thing. So all of these big words that he uses to try to tell Judge Lemon that what he must do are way out of line. He continues saying, dismissing the complaint at that stage when the evidence adduced in discovery may have been sufficient to survive a summary judgment would hardly serve the efficient or just resolution of disputes, which is the very foundation of the federal rules. The law does not evince over concern, especially at later stages of a case, with reverting to the original pleadings when the actual evidence is sufficient to establish a claim or defense later on. But this is completely disregarding the fact that Judge Lyman already said in his order that the MJOP was timely. Because the rules for that is, like we saw, after the pleadings are finished, but not late enough to disrupt the trial date. And Wayfarer did a really good job showing case after case where when they filed was not too late. They backed it up with proof in the Southern District of New York that they filed it timely, and the judge admitted that. And it was the judge's decision not to take the MJOP, which was filed before the motion for summary judgment, and rule on that. He is the one who knows why, decided to put the two together and rule on them simultaneously. That's the reason we are at the stage that we are. It is not because they didn't file an MJOP, which is completely different from this Miller case. And there was no reason for him to delay the MJOP. If you remember what happened and why these extensions were made, Blake had asked for an extension. Not only did he give her the ridiculously long extension, but he gave her more time than she even asked for. That was not necessary to decide the MJOP because the MJOP has nothing to do with the discovery or evidence. Then she asked for a longer extension because of the unsealing, and supposedly it was for the third party's benefit, that the third parties needed more time to submit documents to say what they still wanted to be sealed. But here's the thing. He said that he wanted that all unsealed for the public's transparency so that we could see what he was going to rule his MSJ on. But the MJOP does not involve evidence. It does not involve discovery. There was no reason to delay that other than he wanted to decide those together. He could have decided that a long time ago. There was no reason because it had nothing to do with the unsealing of the discovery. So when Blake asked for that extension, he again gave her more time than she even asked for. But that part makes me angry all over again because we are here with Gottlieb making these ridiculous claims, and Judge Lyman may very well take this, even though it doesn't apply to this case, in my opinion, and say it applies. When all of that could have been avoided if he'd just ruled on the MJOP first, way back then, there was no reason to delay that. He could say the MSJ was delayed because of all that unsealing of the third parties. But for this one, it's just another aggravation to me of these kinds of shenanigans that they play. And now this goes back to Gottlieb's letter. He says, as Miss Lively explained, the second amended complaint alleges more than enough facts to survive defendant's motion. And as Miss Lively also argued, the motion for judgment on the pleadings is directed at the wrong question because at this stage of the case, Miss Lively's claims must be evaluated based on the evidence amassed in the summary judgment record. So what he's talking about is, if you remember, when Wayfarer filed the MJOP, Team Blake wanted they wanted that disregarded, and they only wanted a motion for summary judgment to be considered. And that's what they tried to claim, is that where they were in the stage of time, that it was too late, that it was only time for the summary judgment record. But that just completely ignores the fact that federal law allows for this motion. This is not something Wayfarer made up. This is a rule in federal court. This is a motion that is allowed. This is completely within the rules of what they're allowed to file. And as I said a couple of times already, Judge Lyman said it was timely. It was filed in the right time. So them claiming at this stage it must be evaluated is not a correct statement, because by saying that, they're saying that there is no rule for an MJOP. And that's ridiculous, because there is. And it's funny to me because they're acting like they've got some winning evidence. out there that can beat this summary judgment, which is crazy to me and probably to all of you because we've seen her so-called evidence. But this is what they've wanted all along. So they've pulled this case and said, see, this case proves that what we wanted is the correct thing legally, completely disregarding, like I said, that there is such thing as Rule 12C. Now, there's something more interesting I wanted to talk about at the very end. Miller thus confirms, no, it doesn't, that's just your opinion, that defendant's motion for judgment on the pleadings must be denied. And that's funny because what in the world did that ruling have to do with the motion for judgment on the pleadings? It wasn't even mentioned there. There wasn't one filed in that case. So how does it confirm anything at all? And it does not say that it must be denied because it doesn't even mention a motion for judgment on the pleadings. That it would be appropriate to deem the complaint amended to conform to the summary judgment evidence. I talked about this phrase a while back when they first made this claim. This is something that is not often used. It's very rare, in fact. It involves rules 15A and 15B together, and I explained it in more detail previously, so I'm not going to take a lot of time on it now. But what it means, it's something that's usually done during trial. So if during trial, the other side brings up something that was not a part of the pleadings, something new, then the opposing side can invoke this rule. They can say, hey, this wasn't there, but we need this put in to the case. And so what they do is it's considered amending the complaint. So it's asking the court to go back, even though we're way past pleadings, to go back and add this as if it were part of the original complaints. Now, because it's such an unusual thing, it requires either the other party's consent or permission from the court, which is called leave of court. It's an unusual request. It's very, very rare, and it's not usually done at this stage of the game. Now, in some situations, it can be requested to be done at this time period, but that's even more rare. So what they're asking of the court is not a usual request, and they're asking it like it's just every Tuesday that the court does something like this. So that's this phrase, to deem the complaint amended to conform to summary judgment evidence. So basically, it's asking the court to treat the complaint as if it already included the facts shown by the evidence, even if those facts were not there. So it's asking the judge to effectively update the complaint without requiring the plaintiff to formally file another amended complaint. So it's a big ask, and I've not done it justice here with this little explanation. I have explained it in more detail before, but I need to cut this one cut this one short today because I've got the next video coming up with Omar. So if you come to that, I'm going to ask Omar to explain this sentence too in a little more detail. But basically, this is not just a normal run-of-the-mill thing. This is Michael Gottlieb being Michael Gottlieb and playing around with shenanigans. And I think they got frightened. I think the closer they get to his decision, I think they're really, really sweating it right now. They're worried to death. Today, the sanctions were denied. And I'm sure that they're all in panic and they're desperate to do whatever they can do to try to get anything in their favor at this point. But the fact is, this case is not what he claims that it is not something that the court must deny based on this case or anything like that. So, oh, audio is dropping out? Yes, they will respond, definitely. Probably tomorrow. I think normally, like with all the letters, they have 3 days standard to respond. So, I'm glad they didn't put something out there really quick today. Um, I want them to take their time, and I hope it is saucy and spicy and absolutely fabulous. I look forward to it making us laugh the way they have responded to his shenanigans in the past. But yeah, exactly. They were probably missing that sweet money. Everything they file, whether it succeeds or fails, they get paid for it. So they didn't have a reason to file anything for a while, and now they finally did. And so here we are. They were probably missing those regular document filing billings that they were enjoying so much for the past year. Does the outcome of Blake's case matter if they decide to appeal? I'm not sure what you mean. Can you give me a little more information? Yes, Fritz or Shapiro, or Fritz and Shapiro together. Wouldn't that be amazing? Who do you guess will do the reply letter? I I think it will probably be either Fritz or Shapiro, but if it's them or Ellen, I'll be just as happy with either of the 3 of those. Exactly. Exactly. Um, Ma Mashante Chaton. Machant Chaton. I had learned it, Lena taught me how to say it, but it's been a while since I've seen you, so I haven't been able to practice, and I hope I got it right this time. I'm sure Sloan said they need to file something so they can get a news story splayed in the media ahead of them losing big. Exactly. It's been a while since they had something to put in the news, and this would make amazing headlines. If you know, the way they can blow those headlines up into something that is not true. Yes. When Jed's case got dismissed, I was like, "Please come over to this." I wanted that attorney to come over. What's his name? Charles? What's his name? I forgot his name. He's amazing, but I was like, "Please come join the team. We're gonna miss you if we don't have you here." If Blake wins or loses by jury or summary judgment or whatever, does that help or hurt Wayfarer if they want to appeal the New York Times? They can appeal that separately. So, and if she wins, that makes their appeal stronger. So they can appeal the New York Times either way because that one's already been dismissed. But yeah, appealing the whole thing, if she wins, they get to appeal the whole thing. But even if she loses, the New York Times, they can do that. They can take care of that separately. And if they win, they don't need to appeal, but they can do something called malicious prosecution, which is amazing. And Babcock, thank you. That's it, Babcock. That is amazing, malicious prosecution. And that can bring the Vanzan thing. It can bring so many things. It will be amazing. If they win, they can only do that if they win. So if they lose, they have the appeal. If they win, they can bring malicious prosecution based on this abuse of process and Vanzan and all the good things. Long time the nanny fan. I'll never forget his name. Absolutely. Cece Babcock, right? I did too. I did too. I love that show. I actually it came up on one of my streaming services. I can't remember which one. I hadn't seen it in years, but like last year it came up on I can't remember if it was Paramount or what it was, but it came up and I was like, "Oh, the nanny," and I rewatched the whole thing. Except I think I skipped the last season. I didn't like that one as well. Wash your mouth out, Cassidy, if she wins, huh? Well, Carrie, it was a question by Ocean, so, that if she wins, so I kinda had to say it even though it did leave a bad taste in my mouth. Um, let's see. Yes, Lori Jane, Van scam will be brought forward in Abel's case, right? Yes, because it was added as causes of actions that had actual, criminal, um, situations that could come of it. Not from a civil case. You can't file for criminal charges in a civil case, but it can create a second case that is criminal. But at any rate, the civil, um what is the equivalent to those criminal charges, they did bring those to her case. Now, he did dismiss a lot of her causes of action, which really chapped my hide because much like the ones he dismissed for the other Wayfarer folks, I felt like he crossed a line and made some mistakes, but that's my opinion. But yes, she outright mentions it. So we got a lot of good stuff coming up that and Wayfair has been super, super good about not showing their hand. I think we're in for some absolute delights. Oh, again, see, this keeps happening. Thank you, Michelle, for saying that. I just checked notifications again and nothing for Omar or Cassidy at all. That's why I said maybe she should mention it. Yeah, notifications are not coming up for me. It's happening to several of us. So it must be Omar too. And so I put a post in my community tab just in case that happened. But just to let you guys all know, Omar and I are going live in about half an hour and we're going to talk about the sanctions being denied. And I've tied in the Bravo case that I mentioned in a really, really quick video I did the other day about that case, because it's actually Judge Lyman handling that case, and you'll get to see what he decided in a motion to dismiss with a lot of the same things with Blake. And I've covered the case before, but I was mostly just talking about the sexual harassment situation. But Omar and I are going to go through that and see what that means, or what it could mean for how he deals with Blake's case. So we're going to do that in about half an hour. So Jessica Lisi, Christina Maud's in her sleep. She must. I bet you dream about it. I bet you dream about doing it. Okay. Let's see. Worse than the spray. Yeah, so for those of you who missed it, the other day, when I just started my live, I have this mouth spray that I keep right here that it's for dry mouth. It's supposed to just like wet your mouth really good. And but I had brought a different spray here. They're both in white bottles because I was watching videos while I was drying my hair. I have really curly hair and I like straighten the life out of it. And so I have this spray called blow dry mist. So it's supposed to keep the damage off of your heat stuff. But I was sitting here and I was just about to go live and I like went squirt squirt real fast. And I did 2 squirts before it registered that something really, really foul was in my mouth. I had used the blow dry spray instead of the mouth spray, and it was so gross. Ocean asks, can the lawyers who helped file and allow Vanzan be called to testify? Absolutely. They were subpoenaed. They were deposed. And boy, will that be a fun day or 3 to listen to that. And Ryan could be called. He was not deposed, but that does not mean that he cannot be called as a witness. He stepped up and said, I'm the CEO of Vanzan. So he was listed, Blake listed him as a person with knowledge of the facts. So any person that she listed or that they listed in their initial disclosures or any amended disclosures that came later can be called as witnesses. I mean, technically, even someone who wasn't, but you have to get permission to do that. But absolutely, they were deposed, and they were deposed for a reason. So you better believe that there is some serious worry going on about that happening. Yes, civil violations of the penal code were a thing there. Absolutely. And it was both federal and California laws that were broken. So this is not over with Vanzan. They are not going to let this go. And like I said, Jennifer Abel posted just like last week on Instagram about how she feels about what happened to her. And it was a very emotional statement. And that needs to be followed up. And I really, really, really want there to be criminal um, actions filed. I really do, because this kind of stuff has to stop. And Van Zan, this whole thing that some lawyers were stupid enough to say was clever lawyering or some kind of smart loophole, that that hole needs plugged, because that is not. That is abusive process, and it is not a loophole. It's just something people were doing and getting away with because they weren't caught. That doesn't mean it's okay. No, he didn't. He didn't dismiss them all. He dismissed enough to make me mad, but there are still some left. There are still some left. So, and nothing is past the point of appeal until everything is finished, and it is not. So, yeah, I think something big is coming. I don't think they're just going to let this go. Yeah. Daphne says she was really hoping we were going to come on tonight and say what claims got dismissed. Yeah, we still don't know. Um Christine, it's official. Christina does mod in her sleep. She fell asleep one night during one of mine and went to rewatch. She was still active in the chat for like an hour past when she thought she fell asleep. That is hilarious. Oh, you got a notification. Good. So some of you are getting them. I don't know why some do not. Oh, JJ wants to win says, did you hear about the claim that Blake may have filed her claim on a contingency? That I highly doubt that. Can you ask Omar about contingencies as well? I don't think he pays attention to the chat. Okay, I'll talk about it in there too, but a contingency is when you hire an attorney or a law firm and they agree that you don't have to pay unless you win. And then they don't get paid. You don't pay anything until you successfully win in court, and then they get a portion of that. That would be the dumbest move these people could make if they did that. Absolutely dumbest claim. They'll be the dumbest thing they ever did in their entire lives if they took this case on contingency. And this kind of law firm and this kind of work, like the length of time it takes, all of the filings, the length that it's going to take in court, there I believe now they have to say in the pretrial filings what they think, how long they think it's gonna last, but previously, they mentioned something about 3 weeks. So, like, at the very beginning, because the judge had to, he has to make his schedule out as far in advance as he possibly can. So something was said early on about it being 3 weeks. Now, like I said, with the pretrial filings, they will have to give a more updated estimate now that we're much, much further along in the case and they have a better grasp of it. But a 3-week trial with attorneys like this and the number of attorneys that they bring to everything, every little hearing, this is going to be extremely costly. There, I cannot imagine them taking a case like this on contingency. That would be so stupid. Because if they lose, that means they've done all of this work for free. And no, they're too smart for that. And I don't wanna say selfish because it's not selfish to wanna get paid for your services, but that's usually the kind of thing you do for someone who doesn't have money, is someone who doesn't have money, but you feel has an an absolutely unlosable case. So, yeah, I mean, we'll get Omar's, I'll ask him about that too. We'll get his opinion as well. But my opinion is that would be just absolutely a ridiculous. I don't believe that for a second. All right, let me, oh, a fellow curly hair. Do you straighten the life out of yours? I've been straightening the life out of mine for a very long time. Trish says last year I played a live that Omar and Cassidy did and my toddler went straight to sleep. Yeah. Yeah, we should do some storytelling for sleep. Revealing myself again. Oh, no. I can't be yawning now. I still gotta do another live with Omar. You never thought I had curly hair. Yeah. If I mean people there are probably people who don't know me super well, um, that don't know I have curly hair because I straighten it that often. It's very, very rare that I wear it, curly. Oh, good. Trish got the notifications. It's not legal. That's how. Jesse asks, what they did using a subpoena for over 100 people seems very abusive, and how is it legal? It's not. And that's why they never responded to our motions to quash, because they had no law to support a response. Every time everyone filed a motion to quash, they just released it. Now, they didn't do that to Perez or to Candace or to, what's Popcorn's name? Andy, because those were not in the grouping of 100 people. Those were sent out specifically to them, which is how a subpoena is supposed to go. That's why I called it the Costco bulk subpoena, because that's not how it's supposed to go. And it's not supposed to go to, one like that. Every person is in a different jurisdiction, and every company is as well. We had people like Leanne, she's in the UK. Ashley's in Canada. Google's in California. And they filed it all out of New York instead of through the proper jurisdictions to people from all over the place. There are so many reasons, and I covered that in my letter. And she had no legal grounds to counter what we said in our motions. And so she didn't. She just simply withdrew them. And that's why I was so mad at Judge Lyman, because we asked him for a ruling and he just absolutely ignored our letters. Because if he had ruled on it, he would have had to rule that way, because it wasn't legally sound. And it would have put a stop to her being able to continue to use that subpoena that she was still continuing to use, and got him to extend her time period to use those. If he had ruled on it, he would have had to rule that what we said was true, that it was not legal. And so he just simply ignored it and never ruled. So yeah, I don't care how nice people thought he was at the hearing and how up to date he was on this case. Yeah, he should be. He's been handling this case for that amount of time. Where a lot of other cases that people are used to and why they were impressed, especially in state courts, you get whatever judge is there that day. So you often have a judge that is not well versed in your case. But in the case like this, where the judge has been the only judge and has ruled on everything and sat at several hearings, of course he better know all the details. I'm not impressed that he knows all the details. It's his job to know all the details. But when you're used to seeing things in state court, You would be impressed because in state court, you have judges asking the details because they're not up to date on all the details, but it might be the first time they sat on the case. Maybe 3 other judges ruled on it before them. So, yeah, those are the reasons that that content creator subpoena, um, will always be a reason I do not like this guy. Yes. Yes, that's a really good point. It's one of the things she said. I wanna do, an episode about actually her post. People are still responding or receiving texts that are sent to that wrong number still, and we all know Stephanie still has that phone. So, yeah. So, like, there's been invitations and announcements and stuff where people who she doesn't speak to that regularly, and so they're not aware that that's not her phone number anymore. So she's missed invitations and announcements and things because it's still going to that phone, probably to Stephanie. I've always said that, Christina, that she was been hurt the worst. And in a case where people have been very badly hurt, I think she got hurt the worst. For the rest of her life, she'll have to worry these evil, vile people will release her personal information, her pictures, everything. Yeah, and like she said, there was stuff about there was medical stuff. There was stuff with her fiancé. There were private conversations with her mother. There were conversations with her attorney. Things that are protected, like her medical information and her attorney-client privilege stuff. So, yeah, and just the just the idea. I mean, I am such a private person, like, this would kill me, literally, to have this happen to me. It's really, really awful. Oh, Shorty, you got a surgery coming up? I did not know that. I hope I hope everything goes well. We'll definitely be thinking of you. Alright. I love your comments. Shenanigans, shenanigans of the CGI dragons of Boone Hall, Buckingham Penthouse Plantation. That is a perfect comment. Perfect, perfect comment. That's what I'm starting to think so too, Lori. Or, I mean, it doesn't ha maybe the rulings are coming because he just extended a week. Yeah, I think so. I think because they do want to give the attorney they don't have to, but they do usually want to give the attorneys time to prepare their case for just what they need to prepare for. Just out of I mean, that's just a nice thing to do. It's not required, but they do tend to do that. So, because it was only a week, I tend to think that it's coming in enough time, maybe not within a week, but maybe not long after um, that would expire, that week extension would expire. Okay. All right. So, yeah, Omar and I are going live in about 25 minutes. So, um, I probably need okay. I probably need a moment in between, and, yeah, just Shorty says the same thing. Um, it's interesting, but I don't think so. Yeah. Yeah, I try to stick to, just filings, so those other kinds of things are not usually the kind of stuff I talk about, but if you ask my opinion, I will definitely say, um yeah, that's a good question. Who is bankrolling this? Because she only made $3,000,000 off the movie. All right, let me see if I missed anything. Yeah, Andy got the bulk one too. He had two. He had a personal one and that one. All right, just want to make sure I don't. All right, guys. Yeah, I'm gonna have to call it quits here and try to eat a little something. I've got next to me my half-eaten breakfast from this morning, and that's all I've eaten today. And I don't want to wait till after my live because that will be so late for me to eat. But thank you guys so very much for joining. And about 15 minutes, I will be live again with Omar. So hope to see you guys all there. Thanks again, Christina. And thank you, Ricardo, again. See you soon.